This is a CBS News special report. Good morning, everyone. I'm Major Garrett in Washington. We're coming on the air with some breaking news from the Supreme Court, where the justices have just ruled unanimously on a case that deals with the issue of reverse discrimination. The case, Ames versus Ohio Department of Youth Services, centers on a straight woman who claims she was passed over for a promotion and lost her position to two different gay co-workers. The woman sued for discrimination, arguing it was solely because she was straight. A lower court previously rejected her lawsuit because she failed to show any kind of pattern or historical discrimination by her employer against straight people. Joining me now with the latest on this is our CBS News chief legal correspondent, Jan Crawford. Jan, tell me about Marlene Ames and her claims.
Well, Marlene Ames was a longtime employee of the Ohio Department of Youth Services. And like you said, she was passed over for promotion and then actually demoted, and she lost out to two gay people. So, you know, she thought that was discrimination, and she sued. And she got nowhere. The court said you can't bring this lawsuit because you didn't show that pattern of discrimination, those background circumstances, and they threw out her case. She took her case to the Supreme Court, and in this unanimous ruling today by Justice Ketanji Brown Jackson, the justices said, no, if you're a member of a majority group, if you're straight, if you're white, you don't have to jump through an extra hoop just to have your day in court, just to try to prove your case. Ohio and 20 other states in the District of Columbia required that extra evidence for members of majority groups. So it was harder for white people and straight people to prove their claims. The court today, and this is important, this decision was unanimous, saying discrimination is discrimination. And so now Marlene Ames gets to go try to prove her case.
And for the benefit of the audience, what would the hoop have been to require her?
Like you said, like some kind of historical pattern, which is obviously very difficult if you're straight or if you're white, because, you know, typically, you know, employers don't discriminate historically as a pattern against those kind of
So that
groups.
hoop would have been almost impossible to find.
It was difficult, and certainly it was a different standard. In the courts in those states had established this extra evidentiary burden, while other states, the majority of the states, did not require it. So you had this different level. And I will say, Major, coming out of these arguments, and we went to Ohio and we sat down with Marlene Ames, who, you know, really just wants to prove that she should be able to sue and have her day in court. And it was not something that she necessarily was seeking publicity for, but she believed in this principle. When she got to that argument, it was an excellent case argued by the head of the University of Virginia Supreme Court Litigation Clinic. It was one of, to me, the most clear arguments. It was a slam dunk. I mean, the justices even then were so skeptical. Discrimination is discrimination.
And so, Jan, might this case lead us to take out of our lexicon reverse discrimination? Just call it discrimination?
Right. Well, I mean, and that is what this is. That is what the court is saying today.
Don't modify it anymore. It just is.
You don't need to.
If there's a discriminatory pattern and you can prove it in court, you will get your hearing. And
I think also what's important about today's case is that it was unanimous, because we're entering the month of June, which is always the biggest time, you know, for the court to issue its most contentious and divisive opinions. We're going to have a lot of 5-4, a lot of 6-3 decisions, because those are hard cases. They've divided the lower courts, and they're going to divide the justices. But in the majority of the cases, the justices are unanimous or nearly unanimous, or they have, you know, crossing ideological aisles. Today, it was 9-0, written by our junior justice, Ketanji Brown Jackson. The court says discrimination is discrimination.
Jan,
Marlene Ames gets her day in court.
Indeed. I want to bring in Jessica Levinson, CBS News legal contributor and Loyola Law School professor. Her work focuses on constitutional law, election law, and the Supreme Court. Jessica, your perspective.
Exactly as Jan said, that this is a unanimous Supreme Court saying that when you're a plaintiff and you walk into court and you want to allege employment discrimination under Title VII, that you're not going to have a different standard depending on who you are. As Jan said, this is about the initial burden. When it comes to employment discrimination cases, first the plaintiff has to show that there's enough there, essentially then to say to the employer, now give us some reasons as to why this demotion or termination happened. And then the burden shifts back to the plaintiff. This case is all about the first part of the case, where you walk into court and you say, my employer discriminated against me. There will now not be a harder road for people who are members of a majority group, white people, straight people. Everybody under Title VII has to satisfy the same standard.
Jessica, stand by. And Jan, I want to bring you in because we just got another ruling in a very important case watched by many. The justices have determined whether U.S. gun manufacturers can be held liable for crimes committed outside of the United States by Mexican drug cartels, those cartels using their weapons. So the question before the court was, does that create a sphere of liability for the gun manufacturers? A lower court previously ruled that the gunmaker, in this case Smith & Wesson, was not protected by the federal law that typically shields them, on all gun manufacturers, from liability when their weapons are misused by third parties. Jan, what do we know?
You know, this is another unanimous case. This one was written by Justice Kagan, one of the court's 3 liberals. And again, I mean, I think this
What did the court decide?
They said that the gunmaker, Smith & Wesson, is not liable, that Mexico has no case. And so they've reversed a federal appeals court, the First Circuit, which had found that they could be held liable because the gunmaker should have known that their guns were going to be trafficked and be used for violence by the cartels in Mexico. If the court had adopted that rationale, this would have been a major case, of great significance because it could have opened up gun makers to liability in other contexts, kind of the slippery slope concern. But the court today, unanimous, saying no, that Mexico does not have a case. Mexico cannot recover. So it kind of just is. I mean, the appeals court ruling was a real outlier. And
Jessica, on this case, the court has a history, modern history, of deferring to what Congress says. This is a congressionally passed law, the liability for firearms manufacturers, that had to play a role in this decision.
Well, absolutely. I think you're exactly right to point out this is not a Second Amendment decision. Of course, it deals with gun manufacturers, but this is really a question of whether or not under this federal law, you could have liability for U.S. gun manufacturers. And the beginning of the unanimous decision, as I'm looking at it, is really focused on the idea that you cannot satisfy the aiding and abetting standard when it comes to gun manufacturers. And essentially, that gun manufacturers did not do enough to be liable under the statute. There's actually, the statute itself gives virtual blanket immunity to gun manufacturers, except in certain specific cases like aiding and abetting. The court just said it's all too distant. You can't tie what the gun manufacturers do to the violence in Mexico in a way that under this statute is fair to impose liability on them.
To summarize, 2 unanimous decisions from the United States Supreme Court, one dealing with job discrimination. If you're from a majority group in America, no longer do you have to provide or prove an extra level of discrimination, either statistically or historically, to bring your claim to court. That was a unanimous decision. And also upholding a congressionally authorized liability for gun manufacturers, saying they are not, in this case, liable for third-party use by drug cartels in Mexico. 2 significant unanimous Supreme Court rulings. Our coverage will continue on CBS News 24/7, your local news, and tonight on the CBS Evening News. It's been a CBS News special report. For Jan Crawford and Jessica Levinson, I'm Major Garrett in Washington. Good day.